Looks like we got a pretty good group today. How many teachers? How many administrators? Wow, almost equal here. That's a first. That's good. Glad to have you. We're here today to talk about. I get calls every day on this subject, and I'm general counsel for professional educators. If that wasn't real clear in all the flowery comments that Dewey said, but I'm the one that gets those calls where I've got a child who I had to restrain in the hallway after taking a jab at a student out in the hallway, and I was trying to, and I've got some, so basically, come on in, let's make, I think there may be some room up here.
Excuse me.
Just watch that microphone. Could she sit there, Mr. Techno guy?
I'll sit right here.
Sorry, didn't mean to insult you. I don't know, what's your name?
My name is
Yeah, just wave like this if I do something wrong. Or throw something at me, whatever. But, I have a passion for education. My daughter's a teacher. I went to school, which I think is part of the problem that a lot of people have. They think because they went to school, they know about education. Don't you think that's true? And I'm looking at all of you, you're shaking your heads. And that's frustrating for people like us who have to deal with the reality of the challenges every day of what a teacher goes through. You're stuck in the middle, aren't you? A lot of times. Administrators, you're stuck in the middle, aren't you? Principals, you're the one that talks, the parents call and you're trying to do the right thing. You've got good teachers out there that are trying hard, but you've got to respond and you've got to react. And a lot of those brains out there at that age aren't quite as developed, are they? In the space, in the places you want them to be. So we have incidences, and we have anger, and we have outbursts, and we have absolute, we call it in the Army insubordination, but it's a little bit more than that, isn't it? It's a little fearful at times. I mean, you really don't know what somebody's going to do in a classroom. Today, I've kind of brought the real person who knows how that comes together with the law today. His name is Kurt Kozak. Kurt and I practiced law together years ago. Very bright. He used to be on an F-14, didn't you? So he knows about risks, and he knows how to, he knows the military way, but he also, 10 years ago you decided to go out and teach and leave the legal profession?
11 years ago.
Well, I'm going to let you tell everybody exactly what you're about, but let me blow you up just a little bit more here. But he's very, very knowledgeable about what goes on in the classroom, being in the metro school system, having to deal with confrontation. We have laws on the books that are supposed to protect the teachers, right? You're supposed to, they try, but there's really not a lot of training going on out there. I've had, my calls this past week ranged from a guy, a 17-year-old student who wouldn't sit down, and after 4 times took his backpack and started to run out of the room. Backpack running, looking angry, looking like don't know what's in the backpack. And the teacher grabbed that young man and restrained him. Okay? We'll talk about all of that today, and I bet you all your minds are going, what would I do in situations like that? Kurt's got the sense of realism. He's going to talk about specific situations. He's also got a handout that's got a little color to it. If you're sensitive about obscenity and profanity, don't read it. We're going to pick them back up after the meeting because we don't want your kids to get a hold of this. But these are real statements that are made by these students. I hope you're not squeamish. So, anyway, with no more time wasted, let me introduce you to Mr. Kurt Kozak, lawyer and educator.
All right, thanks, Mike.
Thank you.
Appreciate
You're passing that.
Great, thanks. I retired, I guess about almost 2 weeks ago, and I've been talking with Mike. It's been a pleasure talking with Mike, and maybe we'll work together some. So he's, the thing that I am impressed about Mike so far that I've seen is he's got this congenial manner that kind of diffuses some situations. You know, he'll go to bat for you, of course. But before he does that, he will try to see if he can resolve an issue without litigating, okay? So he is a great guy to call if you have any problems. I don't claim to know. I'm learning about the law again. I've been out of it for 11 years, so I'm doing a rapid reintroduction to the law. So my purpose today is, did anybody see Christy Ballard's presentation this morning? Okay, I thought her presentation was excellent. My focus today is going to be a little bit more on, well, a lot more on the Defiant student in your class. Let's take a look at the definition here of Defiant. I looked at this in the dictionary. Refusing to obey something or someone, uncooperative, insubordinate, subversive, rebellious, unruly, and then my word was disruptive. You teachers in the class ever had any Defiant students? I've had a lot of them, okay, a lot of them. I was at Stratford 6 years, and then at Overton 5 years, and I guess I just want to tell you a quick story. I'd been teaching about 6 weeks, and it was just, I couldn't believe what I was seeing, and I said to my 9-year-old son at that time, I said, Connor, I'm thinking about getting out of this. I'm thinking about leaving. He goes, Dad, you've always wanted to be a teacher. Why don't you just give it a little more time? And I looked over at him. I said, you're a wise young man. I will. So I made it 11 years, okay? a lot of interesting experiences in the classroom. Okay, definitions here. I think I've defined that here. Statutes. For those of you that want to go to see the education statutes, it's real easy to go see. Just go to LexisNexis.com, Hot Topics.10 code. You go to section 49, there's the education code. Click on whatever you want to see. Okay, so it's real easy to do that. And I've got some of the what Mike and I think are the salient statutes here. Just be careful. I have a disclaimer there. I left some parts out here, so there may be situations that are not covered in the statutes here, but just be aware of that. Okay, the first thing I want to talk about is assault. The legal definition of assault. I was assaulted twice this year, where my heart was pumping. Where I was thinking, man, I hope this guy doesn't take a knife out and put it in my stomach, okay? So I was assaulted twice this year, and I've been assaulted other times, but Gene Brooks, my good friend from Stratford, and I are going to do a role play here in just a minute. But let's take a look at the definition of assault. A person commits assault who intentionally, knowingly, or recklessly causes bodily injury to another. Intentionally or knowingly causes another to reasonably fear bodily injury, or intentionally or knowingly causes physical contact with another, and a reasonable person would regard that contact as extremely offensive or provocative. I'm doing a little research for this. The Commercial Appeal says that in Memphis that more than 230 students were arrested for assaulting teachers and other officials in 2.5 years, about 92 per year. Ladies and gentlemen, we're kind of in a dangerous profession, okay? There are a lot of us, a lot of teachers, 92 a year. Let's hope that none of us in this room are faced with that situation. If we are, hopefully this presentation today will help you deal with that effectively. Aggravated assault, unlike assault, seriously bodily injury or death, or display of a deadly weapon. Gene, can I get you to stand up for a minute?
Up front.
Yeah, come on up here, please. Now, if you'll face me right here, I committed, well, here's what I did. I had a student sleeping in the back of my class. I went back and shook her desk. Come on, Miss Smith, come on, listen to me. Her boyfriend was sitting in the back of the room, and he walked up to me. If you'll face me, Gene, he walked up to me and goes, if you ever touch her again like that, you are going to be in serious trouble. Thank you, Gene. Was I assaulted? Look at the definition. This is what I call the heart beating test. My heart was beating. I didn't know if this guy had a knife in his pocket, and I stood there and I said, and I could hear the whole class. This was fun for the class. I could hear him go, and my heart was beating, and I feel that I was assaulted. Okay? Now, I'm looking at number 2 there. Intentionally or knowingly causes another to reasonably fear imminent bodily harm. I was scared. Okay? So, that's the legal definition of assault. Now, what some people in your school district might say, you're not assaulted unless somebody's hit you. Okay? And that may be your school district's policy. I just want you to know the legal definition of assault. If you're scared, you have been assaulted. All right.
Can we
Yeah, go ahead. I'll take
that to verbal assault and physical assault?
I think, and Mike, you might help me with this, I don't think you can be, that's a tough question. Verbal assault, if somebody says something profane or rude to me that's really egregious, like calls me the N-word or something, and I've been called that, I'm sending them out of the class immediately. But I'm not in fear for my bodily, being hurt. Mike, do you have anything?
I would just add that the statute says reasonable fear. You got to add reasonable to it. If somebody says, I'm going to come over there and hit you with this hammer that I have in my hand, I would say that's assault. But if somebody says, I'm going to come to your house tonight and kill you, maybe. But it's usually immediate, reasonable, fear of bodily, and maybe other things, hostile threats and stalking or other things. But it has to be coupled with, at least the courts have ruled, it has to be coupled with some reasonable perception that you can, like what he was doing, he was an inch to his face. Proximity has something to do with it. What he's saying to you does have something to do with it. But not always. But if you have a reasonable fear of imminent bodily harm, you've been assaulted. Some states separate. You and I talked about that. In some states, like Ohio, assault and battery are 2 different things. Assault is the imminent threat and the fear. But Tennessee combines both of them. We don't have battery in Tennessee. Battery is the actual striking. Assault is the reasonable. Yes.
What did you do with that? So did you report them to the principal?
Oh, yeah, immediately.
And then did you have a consequence or suspension?
Oh, yes. I'll address that right now. I want to talk about it a little later. We're going to talk about a case like that. But fortunately, I had a good principal. I'm glad we have some administrators in the room. I had a good principal. I told him what happened. I immediately got security down. They escorted him out of the room. And the student had not done anything all year, nothing. And I said to my principal, I don't want him in the class again. And he said, okay. And we'll talk about a case where that didn't happen, which is really interesting. So, to make a long story short, I never saw him again. The principal helped me out and didn't put him back in the class. So, but I stood up there and I was very obsequious. Yes, sir. I will not ever do that again. I just looked him in the eye and just was thinking, please, don't hurt me. I'll say anything you want to, and then we're going to get you out of here, and we're done with it. Okay. Yes, sir.
Is threat synonymous with assault? In other words, I typically don't tell a student you're assaulting me, but I'll tell the student that sounds like a threat. Is that synonymous?
I think the key is, do you reasonably fear bodily injury? Okay, and looking at the outline here, aggravated assault, just so you know, seriously, go ahead.
You may have other things there, like criminal menacing and stuff like that, if you're talking about threats. So there's other things that they can,
No, it's fine.
does that make sense to you? The difference between, if it's distance, proximity, reasonable, imminent fear of bodily harm, you know? I mean, if he's in your face, like he was threatened, he reasonably, I think anybody in his situation would have felt like he was in harm's way. Is that a fair statement?
Oh.
You know, I mean, nose to nose and girlfriend, boyfriend understanding, and his anger, his temperament, he's spitting in your face probably while he's talking. I mean, come on, there's something's gonna happen. And I gotta tell you, man, you handled that very well. I mean, I don't wanna embarrass you by bringing it up, but I don't, you know, it's hard to stand there and have a student say that to you, and you kind of diffuse this situation by saying, yes, sir, that's the way it's going to be, and then handle it the right way by going to the principal. And that's hard, isn't it? It would be hard for me. If I was a teacher, it would be hard. So you get the Rise Above Award.
All right, thank you. All right, reporting child abuse, that really isn't on topic here exactly, but I've seen some students that are kind of defiant or disruptive in class, and you know, I wonder, we've all done this, you wonder what they're going through at home, the stories at home, what they're going through. So I've told a couple of people, my principal, you know, this young lady, I'm worried about her. She might be being abused at home. So just make sure you report that if you have any inkling that might be going on. Now, the next topic here, suspension of students, expulsion of students. As I got into this a few days ago, I'm thinking, wow, the legislature has really given the schools a lot of power to deal with disruptive students. You know, maybe a lot of us are upset with the legislature a little bit with testing and evaluations and that stuff. But they've done a great job here for handling the disruptive student. Now, any principal, teacher, or assistant principal of any public school in this state is authorized to suspend a student from attendance at the school, including its sponsored activities, or riding to and from a school bus for good and sufficient reasons. Good and sufficient reasons for suspension include, but are not limited to. All right, I'm going to let you guys look at that, and now we have a little group activity. Now, this is a real-world situation. This was probably in the top 3 of my Defiant students in 11 years. Okay, so if you're, our principal said, if you're writing a discipline referral, you describe it exactly what the word said. So please, we'd kind of like these back because we really don't want your kids to see them. So anyway, what I'd like you to do is work with some people at your table. I want you to go through this handout that Mike is handing you right now and look at all the different violations or ways this student could have been suspended. Okay? Now, please start at the bottom. Okay, I started in August, and this is all through the year, August through May. So start at the bottom, and I did this, and I stopped counting at about 4 or 5. I just want you to be familiar, especially you administrators, familiar with the power the law gives our school officials to deal with defiant students. We'll give you probably 5 minutes, but please work with somebody next to you there and just count how many reasons that this student, I call her Debbie Defiant, how many ways she could have been suspended, and she was suspended periodically. She was never expelled. But please look through that. And we'll go for about 5 minutes. and just circle or whatever number, how many ways she could have been suspended.
Oh, okay. They kind of cross the
Okay, about 3 more minutes, please. Thank you. I heard that. Thank you.
That would be my very first question. I don't In this case, I haven't made it all the way through.
They do, they have a lot of
Rather than us. We place them.
I'm sorry.
Okay, okay, I think it's fairly obvious that Defiant Debbie broke a lot of laws here in Tennessee. Does anybody want to start with one of the sections? Anybody have one?
We had a lot of ones and twos.
Okay, willful and persistent violation of school rules. Okay. Obviously, immoral or disreputable conduct or vulgar or profane language. Obviously. Okay. So we have those two. I had those two. Number six. Okay. Defacing the calculator. And I just, as a math
It'd be a
teacher.
number 4 too, because that was willful.
Yes, I just like a TI-84. They're like $100. Don't ruin those, please. That hurt me so much to see that scratch there. But 4 and 6. Anybody else? Number 9. Okay.
Assaulting the teacher.
Yes.
Number 9, yeah.
Yelling in my ear that one time, and then slamming the door a couple of times. I mean, when she slammed the door, everybody in the class just kind of went, oh. No, it's
See,
just,
that goes back to his question. This statute uses the word assault.
That's that's an assault. We'll be taking it.
yes, that's a good point.
So, I mean, when you use assault,
But does a reasonable person
yeah.
think that that's an assault?
I think if they're going to, it's almost ambiguous, that part of the statute. It may need to be clarified and rewritten, because assaulting a principal, teacher, school is using a different language than assault is defined in the statute. So whoever I think these two gentlemen brought that up. It's an excellent point. Sometimes our legislators don't know how to write. And I'll tell you, Pat spends a lot of time rewriting legislation and submitting it to committee, so it's clear. So that's a very good observation, using assault in that.
yeah, personally, ladies and gentlemen, as a teacher, I would use the assault definition if I'm reasonably in fear, because we've all heard profane language, and so that's just me personally. Okay, let's see what else. I see another one here. Anybody got another? I had another one.
She didn't get a referral for this, but I would have referred her for March 11th when she left class without permission and did not return. I mean, when a kid just walks out of your class without permission,
Yeah.
that's definitely a referral.
Yeah,
right
absolutely.
there, because that's a safety concern, because nobody knows where that child is.
Good point.
Number 13.
Number 13 too. That's a really good point on the referrals. I tried not to write a referral every day.
Well, in most situations, though, you immediately call an administrator and they begin looking for that child because you don't want them. That's how it happens at our school. We immediately get an email or we get a front call down to the office saying such and such just left class.
Did everybody hear
And
that?
so that we already know as an administrator what has happened. We don't need another referral.
Okay, good.
Unless she assaulted you or verbally assaulted you.
Okay, good. Thank you.
What's your first name?
Kurt.
Kurt.
Same as this.
Kurt number 2 over here brought up a good point about unruly that I don't want to miss. Does the principals here use that in your local district with the sheriff? I got a man back there shaking his head. Can you tell us how you use it?
Just repeat what they said.
What are you talking about?
Obviously, you got a troubled student here, and you've got, well, go ahead.
I said that the very first thing that I came to, it said referral number 14. I said that after referral number 14, I need to start looking at filing an unruly petition on the student. And the magistrate that we work with is very rigorous with us in determining whether or not it is an unruly petition. They won't just file one because we have to prove that there's a pattern of behaviors. But after 14 referrals, I feel that there's a pattern of behavior, and I would have already filed an unruly petition with our juvenile courts on this student.
So schools can, I know parents can do that, schools can do that?
Oh, yes, absolutely.
Williamson County does it all the time. And if you sit in there and watch some of them happen, they'll bring the parents in too, and it will become a family situation. It's not just I've seen the school bring it, but they'll bring the parents in too, and they'll tell the family this is the way it's got to be. You're responsible. You know, obviously your child is doing something in school. Were you aware of it? What have you done about it? What are you going to do about it? If you don't do anything about it, guess what? You're going to be in trouble. Now, that's a little strong, but I've seen that happen.
Judge Guffey, who is our juvenile judge in Williamson County, is very, very good.
Yeah.
And she really supports the school.
Looney, what was his name? Hoover used to do that.
Judge
Hoover did that.
And Judge Nations.
Nations.
Is there an age limit on that? I teach first grade, and I would have told you last year I could have had a few. But obviously I don't feel like they're going to maim me. I mean, I'm bigger than them. But they are disruptive.
Did you just use the word maim?
Yeah.
That was good.
We've got a case on that in a minute.
But I'm telling you, there are definitely kids that were disruptive.
I don't think there's an age limit on juveniles being brought. If somebody does know a limit, then I'm wrong, but I don't think so. I think you're a juvenile and you're under the juvenile jurisdiction. And you can become an adult after a while, indeed. So, yeah, how old are you talking about?
Well, I could, the ones I had this year, honestly, I could maintain. And then these children, the one I'm going to refer to right now, were not in my class. But there were certain kids that, I did have one actually that the year before bit people and did all this stuff. And he didn't do that in my class at all, but the year before was rough for him. And he would run out of his room and then he would run through everybody else's classrooms and they would like be chasing him through the school and through the cubbies. So you could file an unruly for someone like that.
I think it depends on how long it's been going on and what they've been doing. Go ahead.
I think you need to really look at whether or not a youngster, I don't know if he's 9 or 10, is going to understand standing in front of a juvenile judge and whether or not that's a consequence. Now, there are some other things that you could look at in that situation. You could probably go into more in depth about this with the parents.
Right.
Educational neglect,
There you go.
something in that respect.
Was this child ever suspended?
I think so. I think she was suspended several times during the year and she came back. And then they did the suspension, obviously.
Was there an alternative educational setting that this child could have went to for the remainder of the school year?
I hoped that there was. Please get it.
And I guess the reason I'm saying that, then we would have been like what the gentleman said, we'd have never got to 14 referrals. She would have been out of the juvenile ed population to alternative learning settings.
Well, I don't know. That was up to the administrators, and I really didn't.
What about, like, was this kid referred to a guidance counselor or for any testing at school?
Oh yeah, she was disruptive.
She had a file?
And she didn't have an IP, from what I recall.
That was my first question, was whether or
Yeah.
not this child had an IEP or even was in the pipeline for testing for an IEP, because in that respect, now we have to go through due process
Did you,
with that student.
did they do a functional behavior plan with the child?
I don't know.
It would have involved you if they did.
Probably not.
Yeah, it would involve the teacher.
Yeah, it would involve the
It would
teacher.
involve every teacher, all her teachers.
Yeah, you should know about it. If they haven't.
Yeah. Now, I'm going to skip 40 TCA 49.6 4102. I want to go to 4106, discipline referrals. Now, administrators, I don't want to offend you here, but I think some of us teachers have heard things like, "Don't write. You're writing too many referrals." Now, I say my advice is to document what goes on in the classroom. Because if we had ever had a hearing in front of a magistrate, this is a lot more powerful than me saying the magistrate, she is just really disruptive. This is powerful. So, and you teachers, I know we don't like to do this stuff. What I did every day, I said I'm going to dedicate 15 minutes every single day to discipline issues. Now, hopefully you don't have that at your school, but I had to do that, and I just looked at it as part of my job. I don't want to do it. I'd rather be doing other stuff, getting ready for the class tomorrow, or doing stuff with students. I don't want to do this, but I'd look at my watch. I'd say, I'm 15 minutes. I'll write if I have to write 2 or 3 referrals each day, I will. And that's one of my notes on the, right there on the bottom there, discipline referrals. Write referrals, okay? Now, we're going to get into another area here that's, the law has a lot of interpretations. The use of reasonable force, 4107. A teacher, principal, school employee, or school bus driver in exercising a person's lawful authority may use reasonable force when necessary under the circumstances to correct or restrain a student or prevent bodily harm or death to another person. My guidance on that is I would never touch a student that I didn't know well. I mean, we all pat students on the back and give them high fives. We do that. But if you don't know a student, be very careful about touching that student. Now, obviously, you can use reasonable force if 2 people are fighting and somebody's really hurting another person, obviously. But personally, guys, my first week in school, I had a teacher tell me, a friend of mine tried to break up a fight between 2 big old boys and was slammed against the wall, and it was never the same again. And I remembered that lesson. And I don't mean to say I'm scared or anything, but if there was a fight in the hall, I went to my phone, called the SRO. You need to get down here right now. So I would just be very leery about touching a student that you don't know. Let me give you another scenario here. A friend of mine, we were out in the hall, and the principals come over the loudspeaker and say, please help direct students to their class. You have a couple of minutes to go. Please help students get to the class. There were a couple of guys standing up against the wall, and one of them, my friend, a fellow teacher, went up to one of them and said, come on, buddy, you need to get going. That guy obviously had a mental problem, because he turned around and grabbed my teacher friend and threw him on the ground and started punching him. Now, obviously, the teacher was assaulted. Fortunately, right next door, we had an ex-football player, teacher, that immediately got that student off my friend. The only thing that I would have done differently is I wouldn't have touched that guy. I would have said to him, hey, buddy, you need to get going, okay? Because I didn't know that guy, okay? And if it's somebody you know and they're in your class and you feel comfortable patting on the back or something, that's fine. That's the only thing. And my friend didn't do anything wrong. He was just trying to be friendly. But the gentleman, the student that he hit on the back, obviously had some serious mental problems, and he didn't like being touched. And he didn't like being told to do something. So he turns around and grabs my friend and gets him on the ground and starts punching him. So my advice, take it for what it's worth, is don't touch anybody unless there's a really good reason to touch them. Okay, so use of reasonable force. Now, does anybody want to, Mike, do you have any guidelines on reasonable force that you might share with us?
Well, I think all the schools have training about, but oftentimes that doesn't get to what the area we're talking about. Like I had situation where, like I said at the beginning, a kid was defiant, angry, wouldn't do what he was supposed to do, grabbed his book bag and ran out the door. Well, that pretty much intimidated the teacher to grab the child and restrain him because he was running. Danger to himself, danger to other students, not knowing what was in the book bag. Everything ended well. But that could have been a mess. It could have been a real mess. The only other thing I would comment on is the referrals that we kind of went through real fast, because we've got principals here. And I think that goes to the relationship with the teacher and the principal, as far as making sure everyone understands what's referable and what isn't. I mean, some people may just give 3 a day and not think anything about it, but you know, it's part of the teacher's job to control the teaching environment to the greatest extent possible, but not to the point of being put in danger or putting the students in danger. So I do hear about that as general counsel for PET, you know, from principals and teachers, that there's a misunderstanding about the number of referrals and what should and shouldn't happen. And it really takes a dialogue instead of, you know, does everybody kind of agree with that? That's a rapport relationship thing. You can't work in a vacuum. And, you know, if you got one teacher giving 50 referrals and one giving 0, and, you know, something's wrong. You know, there's got to be some balance there, some common sense approach. That's all I wanted to add to that.
Can I ask a quick question? Going to the reasonable force, the older I've gotten, the less I want to get involved in separating the fight. Is there a legal problem with that? If I see 2 guys fighting and I just call on the phone for help?
Yeah, that's interesting. Last year I had a fellow in the back sitting right where Tim is sitting right now. He asked me, he goes, you know, I'm in the locker room, and, you know, if I stay there, they think I'm being prurient, sexual. Was it you? No, but somebody last year asked that question. Or if I leave and somebody gets into a fight, am I going to be legally accountable? And that's a tough question. And I don't think you're responsible for getting yourself hurt. I think you're supposed to do what you reasonably can under the circumstances. Like Kurt said, get on the phone. I'm the same way at my age. I'm 61. I don't know how old you are, but things break and crack and pop that never used to pop and crack, right? And the strength isn't there, but getting help, I think, is essential, and calling. I don't think if there was a teacher that was brought before any board or any lawsuit or anything against the school, I mean, I would defend them to the hilt for doing what was reasonable under the circumstances. I don't care if you're a football hero and you're 26. I mean, you weren't. If you could, and it's just the circumstances. You know, I think you have to look at the circumstances. But it's a very good question, and it's a tough paradox. I mean, you just. And when the guy asked me that question, it was like,
Locker rooms and buses, those are the 2 hardest things that we deal with as administrators. So what we told our teachers to do is we prop open the door because there's a wall that when you look into the door, you just see the wall. So you can't see anybody changing in the locker room. So they prop the door open and stand right next to that door, and your ears are listening.
That's a good policy. That's a good
Because
policy.
bullying happens in those locker rooms.
Mhm.
We know it, and so we try to correct it as much as we can.
Good point.
Okay, testing of students for drugs. This really isn't a teacher thing, more of an administrator thing. You can do it under certain circumstances. I used to think, as a teacher, you know, this guy is really disruptive in my class. I wonder how disruptive he'd be if we said you're going down to do a drug test right now. So, but my schools never did that. I always wondered if that would be effective. A couple other things. I want to make sure that on the third page, applying the law in your classroom, we've covered F, and I do want to cover E because I think it's great that we have a fair number of administrators here today. Teachers should have the support of administrators. Administrators should never question a teacher in front of the students and should support the teacher 100% in front of the students. Okay, if the teacher has done something really stupid and you're an administrator and you come into the class and you say, the teacher says something, I want this guy out of the class, and you're going, oh man, what's he doing? Come on, Mr. Jones, you're leaving this class. Mr. Kosak wants you out of here. You're leaving right now. The time to discipline or talk to a teacher is in private, okay? I have heard, when I was a young teacher, unfortunately, I had some principals that would come down. I got a class of like 30 unruly students at Stratford High School, and this teacher starts questioning me in front of the class. And I'm going, come on, I'm here to teach. I'm trying to teach this geometry class. I will talk with you after school. And if there's a problem, let the teacher know in private, because the last thing you want is for the students to get the idea, oh, the principal is really not on his side. I might be able to get in between them. So, another thing that I had happen, unfortunately, I would send a student out with a referral, and I had some administrators who would send him back that same day, 45 minutes later, and they'd walk in the class and go, I'm back. So, at least, as an administrator, at least keep them out of that class the first day, at least. Okay, so I wanted to make sure I covered that. I want to talk a little bit about this really interesting case, Michaela Babb versus Hamilton County. This, I think, was a second grade teacher. She had a student hit her in the face, and the student was suspended for 10 days or something. And there was I'm not going to get into the IEP question of it, but she didn't have an IEP, but the federal court decided that she should have had an IEP, so they went through these IEP rules. Okay, the student comes back, the principal brings the student back about, 10 days later. The student hits the principal again, the teacher again, the second time. The teacher sues the school system and says, I've been injured, and I didn't sue the first time, I'm suing the second time. The student should not have been brought back in my class. The federal court ruled that it was unfortunate that the plaintiff was injured by the young student while performing the duties of her profession, but there's a Government Tort Liability Act, which is kind of a confusing act. Basically, what the federal court said was this administrator was using their discretion to put the student back in the classroom. Now, I have a note here that we teachers, we need to be courageous. We need to stand up for ourselves. Here's the way I think that case might have been settled. When the principal said, we're bringing that student back in your class, and you can imagine how that teacher thought, this kid's already hit me. I don't want him back in my class. Getting back to this case that I had where the student threatened me, I was going to be real nice with the principal. I was going to let the principal decide I told him I don't want him in my class. But I didn't say to the principal, and this is what I was going to do. If he sent the student back to my class, I would have said, no, not going to happen. It's not going to happen. Period. Okay? And that's what this lady should have done is said to the principal, no, that student's hit me, and he's not coming back in my class. And if the principal said, yes, he is, I would have called up Mike and said, Mike, look, I'm scared. I'm scared. And Mike is great talking to these superintendents. Hey, Joe Superintendent, we got a little problem here. One of our pet members has a child in her class that's already hit her, and she's scared. Can we move her out of that class? What do you think the superintendent's going to say? Oh, yeah, Mike, we can do that. We'll have her out of there tomorrow. Okay, so my point is, Ms. Babb I think this is bad law. I'm sorry. I think it's bad law. But that's what it is. And I'm just saying, occasionally, if you're in fear as a teacher, you need to say, no, I'm not going to do it. That kid's not coming back in my class. So I found that to be a really interesting case. Okay, just some other things about applying the law in the classroom. We've got about, yes ma'am, yes ma'am.
And this is probably, you're going to tell me we need to address it another time, but, when we're dealing with special education students, I'm not a teacher anymore, I used to be, but, daily, we would get injured. I mean, daily, all the time. But we knew what we were getting into. We knew we knew our students and those kind of things. But where does that, is there any protection for those teachers and paraprofessionals that get hurt on a daily basis? And we know that that child is due to his or her disability and those kind of things. And a lot of times it is the least restrictive environment in a self-contained classroom and things like that. But getting hit, I mean, I've been stabbed, hit, kicked, strangled, all those kind of things, but I mean, you just kind of chalk it up to.
Well, I'm going to
What
have
you
to
do.
I'm going to have to pass that one over to Mike.
I mean, I've just always been interested and to ask the law lawyer,
I was afraid somebody's going to ask me.
I know, sorry. I had no problem. I actually never did a lot of referrals unless the principal went over my head and said we're referring, because of that. The strangle one, yes, was referred over my head because it needed to be. But I'm just wondering where the protection is for those, because we use CPI and all that stuff too, but you still get hurt. I mean, you can.
Well, the IEP is not a complete defense to behavior, whether it's, a cause of their disability or learning disability or what. So it needs to be stopped. And I had a teacher that was special ed, and she was being bitten all the time, and so she started wearing gloves.
Right.
And I won't tell you what else she did because you may have heard about it, but she put some deterrent on the gloves so that, which was very harmless, but it was not smart to kind of do that without talking to the parents, without talking to some. Our protection of our special ed teachers goes like this. If they're getting hurt and they're getting bitten and stabbed, and we have to stop it. Now, whether that child is legally responsible for what they're doing, that's over here. There's still a responsibility and laws that apply to the school that you have to create a safe learning environment for the other children and for the teachers. So whoever says, because it's an IEP, that it does not need to be addressed, they are very wrong. Because there are other children in that classroom, there are teachers, there are other things going on, and so.
Well, not to be interrupted, but I mean, FBAs are being done, behavior plans happen, it does get better. I'm just saying, in that initial part, when you're waiting for all those things to happen, it occurs, we know that progress can be made, and it is, and that's why you do it. You endure those things because
absolutely.
You see the end result.
Has anybody had this problem with their school?
The situation that I find is that you're right. We put those things in place because the school has to do everything it can do before you can determine if that's the appropriate placement for the student.
Right.
So we have to document and show, these are the things we put in place. This is not the appropriate placement.
Right. But during that time when you're doing that, you do have to endure those things. But I'm just thinking, I've had paraprofessionals come up to me and go, how much do I have to, and they get frustrated and they want thinking about, and they do incidents reports and all those kind of things.
Right.
But, it comes to a point, and then you're losing good people because of that.
Well, and the plan's not working.
Right.
It's just not working because, like you said, you spend so much time putting it together, and yet all this is going on. People are getting hurt. That needs to be revisited. That is, I see too much IEPs that are not revised as needed to develop in circumstances like this. There's no law that says, and it should, and IEPs are tough, I mean, they're a challenge, you know, I mean, to balance the rights of the child with the school environment and the rights of other students, it's hard. But if that happens that early on in an IEP, something's not working. And I'm not pretending to know what you went through, but I admire you for your commitment.
I mean, this is not one particular student, this is
Oh, I
like
know,
several.
I know. I get
I'm
calls.
not saying I endured all that by one person.
Absolutely, but it happens all the time.
Right.
It does, and it's usually this, you know, teachers that really care, and they go and they do ask that, how much do I endure? You know, I'm going home with bruises every night.
And I never really asked it, but when I got married, my husband's like, okay, you're coming home with all this, like, when is it enough? And I'm like, it's not, it's just.
Is there assumed responsibility or assumed liability of the teacher knowing that they're getting into that job?
Well, there's
That's
assumption of risk.
That's a very interesting legal question.
There is assumption of risk, but still,
Okay, yeah.
and knowing what you're getting into, but there's also a factor there that, you know, the plan is just not working, you know, and it is when they go into that profession. But I don't know that a lot of people that go into special ed
I don't think they're aware of it.
don't
There's a lot of
realize.
new-
I mean, I've seen some stuff that are just unbelievable that are adult. And some of these people, some of these folks, special students, are very big, you know, and you know, they come, and a lot of it is to distract you from teaching them, right? I mean, that's a lot bigger.
Oh, well, they're trying to
bigger-
escape, and then if
Yeah.
they get suspended, then it makes it worse because they
Right.
have to be by themselves.
Right, so it's a very complicated question, and I wasn't
Then you
kidding
get
when I
into
said,
students.
I was afraid somebody's gonna ask that, because there are schools of thought about how to handle it. I tend to look for the teacher, okay? But I do have a granddaughter that has an IEP, so I understand the issues. I don't think there's an easy answer. I just know when you're getting beat up and hurt, it's got to stop. And whatever you have to do to address the school resources, SRO, I mean, I hate to say it, but, you know, punching somebody in the face is illegal. Okay, you can talk about intent later, you know, but that's not going to happen, so.
What concerns me the most, I'm a special ed teacher that gets bit all the time too, but they continue, well, I've seen just, I've been teaching 15 years just special ed, and they continue to take away our supports. You know, gosh, when I started teaching, we could physically strap them into a chair. Then we had safe rooms that were padded, and we
We
can't
had
use those
assistants
anymore.
too,
And then,
more
like,
people.
even just, I just attended my CPI refresher last week, and used to, we could block a punch like this. Now we can only block a punch with open hands like this. But my hands are actually pretty weak and will bend backwards. It's not gonna, my hands are not gonna block a punch from a 16-year-old boy, I'm sorry. So that's what worries me the most, is every year they take away more and more of how we can protect ourselves. They gave me arm guards, padded arm guards to wear because I was getting bit so much. I mean, what am I gonna start wearing a full body armor?
Well, and a lot of that comes from lawsuits and people.
People lose their common sense.
Right. The lawsuits are frivolous at times, and they really defeat and dilute the protection of it and the learning environment and the mainstreaming and everything that's going on. So all I can say is yes, I know.
Go through the rest of that. Hopefully some of that's helpful for you. Thank you for your attention. Appreciate it.
Thank you for your participation.